BR1 Number 10. State of Connecticut. Department of Labor. Employment Security Appeals Division. Board of Review. 38 Wolcott Hill Road, Wethersfield, Connecticut, 06109. Claimant's name, Philip P. Bernal. SS hashtag. Employer's name, address and reg no. Best Buy Stores, LP. C/O Unemployment Services, LLC. P.O. Box 749000, Arvada, Colorado, 80006, 9000. Board Case No. 943-BR06. Referee Case No. 976-CC06. Date mailed to interested parties, August 25, 2006. Decision of the Board of Review. Case history and jurisdiction. The administrator ruled the claimant eligible for unemployment benefits effective April 16, 2006, and notified the employer of its chargeability on May 2, 2006. On May 22, 2006, the employer appealed the administrator's decision to the Hamden Office of the Appeals Division. The Appeals Division scheduled a hearing of the appeal for June 21, 2006, which the claimant and the employer attended. By a decision issued on June 21, 2006, Principal Appeals Referee Herbert R. Pelly affirmed the administrator's ruling. The employer filed a timely appeal to the Board of Review on July 12, 2006. Acting under authority contained in General Statutes 31 to 249, we have reviewed the record in this appeal, including the tape recording of the referee's hearing. 2 Issue. The referee ruled that the employer discharged the claimant for reasons other than willful misconduct in the course of his employment. In support of this appeal from the referee's decision, the employer reiterates its contention that the claimant purchased game consoles at a discount in order to earn a profit holding video game tournaments. The employer maintains that the claimant knew that he was violating company policy by using the employee discount to purchase equipment for use in a personal business. The employer also maintains that the claimant can organize future tournaments such that he will ultimately use the items he purchased for a profitable business. The issue before the board is whether the employer discharged the claimant for willful misconduct in the course of his employment. 3 Provisions of Law. Section 31-236, A, 2, B, of the General Statutes provides that an individual shall be ineligible for benefits if he or she was discharged or suspended for willful misconduct in the course of employment. Section 31-236, A, 16, of the General Statutes, as amended, defines willful misconduct, for purposes of the Connecticut Unemployment Compensation Act, as deliberate misconduct in willful disregard of the employer's interests, or a single, knowing violation of a reasonable and uniformly enforced rule or policy of the employer, when reasonably applied, provided such violation is not the result of the employee's incompetence, and provided further, in the case of absence from work, willful misconduct means an employee must be absent without either good cause for the absence or notice to the employer which the employee could reasonably have provided. Under the circumstances on 3 separate instances within the 12-month period preceding his or her discharge. Except with regard to tardiness, each instance in which an employee is absent for 1 day or 2 consecutive days without either good cause for the absence or notice to the employer which the employee could reasonably have provided under the circumstances constitutes a separate instance. 4 Findings of fact and conclusion of law. In the case before us, the claimant received an employee discount of $2.70 on 3 video game consoles used in a tournament that he volunteered to organize. Although the tournament participants each contributed $10 to defray the costs of the event, the referee found the claimant credible in testifying that he did not make a profit, did not intend to organize any similar tournaments, and has retained the consoles for his personal use. There is nothing in the record that would cause us to overturn the referee's credibility determination. The claimant made no attempt to hide the transaction, which only resulted in a very minimal discount for the claimant. We thus concur in the referee's conclusion that the claimant did not knowingly violate the employer's discount policy. We find that the parties have not offered any argument in support of or in opposition to the appeal which would disturb the referee's findings of fact. We further find that the findings are supported by the record, and that the conclusion reached by the referee is consistent with those findings and the provisions of the Connecticut Unemployment Compensation Act. Accordingly, we adopt the referee's findings of fact and decision. V. Disposition and order. The referee's decision is affirmed and the appeal is dismissed. The claimant is not disqualified from receiving unemployment compensation benefits effective April 16, 2006. Board of Review. Amy Stillman Colleague, Acting Chair. ES Board of Review. In this decision, Board Member Florence Prescott concurs. Ask SNBLM. If you wish to appeal this decision, you must do so by September 25, 2006. See last page for important information regarding your appeal rights.
I'm telling you right now, I'm instructing you, take me to court. Leave your nonsense off YouTube. If you have a problem with people using your video game footage in a Let's Play atmosphere, take me to court. Because I'm not taking down any of my videos. I am going to fucking stand my ground for all gamers. And I believe that Let's Plays are transformative work. And I'm not going to let you push me around. So I told him, take me to court. I'm done with this. I've been doing this now since 2008. I'm not going to put up with this corporate bullshit anymore. And you know what? I hope they do take me to court, because at this point, I'm done with this. We need a legal precedent to be set to state that we are gamers and we are protected and that we are not going to be persecuted by YouTube's shitty automated system, by any Joe Schmo fucking game publisher who tries to double and triple dip. I paid my $60. I bought the license to play your game. My gameplay is my original content, not yours. Go fuck yourself. Period.